Okay, we'll start again. I declare this public hearing of the Standing Committee on Employment, Workplace Relations, Skills and Training for its inquiry into the operation and adequacy of the National Employment Standards. We'll do some brief introductions. I'm Karina Garland. I am the chair of this committee, and I'm joined here in person by
Asham Behabaha, the federal member for Barton.
Libby Coker, member for Corangamite in the beautiful state of Victoria.
And I believe we may have people joining us online and in person as the hearing goes on today. I begin by acknowledging the traditional owners, custodians of the land on which we meet today, and pay my respect to their elders past and present, and extend that respect to any Aboriginal and Torres Strait Islander peoples joining us today. In accordance with the committee's resolution, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will also be published on the Parliament's website. I remind all present that as Chair I will ensure that proceedings are conducted in an orderly, respectful and courteous way. Those present here today are advised that filming and recording are permitted during the hearing. I remind members of the media who may be present or listening online of the need to fairly and accurately report the proceedings of the committee. I've just been advised that Ms Lawrence in WA is now on the line, and Ms Roberts, also from WA, are on the line. Excellent. I now welcome the witness from the Australian Industry Group to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
Brent Ferguson. I'm the Head of National Workplace Relations Policy for the Australian Industry Group.
Thank you very much. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you. And I note I've got Ms Cruden here with me as the Legal Practitioner Director for the Australian Industry Group.
Thank you very much.
Look, we thank the committee for the opportunity to contribute to its consideration of the operation and adequacy of the National Employment Standards. To provide some context for our evidence, the Australian Industry Group is one of the largest and oldest registered employer associations in Australia. We're also recognised in the workplace relations system as a peak council of employers, and we also operate one of the country's largest specialist law firms practising in the area of workplace relations and employment law. We've also been involved in virtually all of the variations and proceedings or parliamentary processes associated with the development of the National Employment Standards, and we've played the leading role in essentially all of the major cases developing award terms that supplement the National Employment Standards. So within that context, we've obviously advised thousands of employers ranging from small family business through to multinational corporations across a myriad of industries. I think it's important for this committee to appreciate that, of course, the NES is a central pillar of the workplace relations system, but it's also crucial to understand that the NES is intended to operate alongside modern awards. So the modern awards and the NES are contemplated in the Act as together providing a fair and relevant safety net of minimum terms and conditions. And of course, the Fair Work Commission is charged under the statute with ensuring that the awards and the NES together do provide that fair and relevant safety net. Relevant in that context means that it's relevant in the sense of it meets contemporary circumstances. So the point we're making is the safety net is not set in stone, and there are avenues for parties to seek the Commission to develop supplementary terms and conditions beyond what is in the legislation. Of course, the NES has also been varied many times since its inception, as we outline in our submissions. It's also, I think, important for the committee to appreciate that the NES, by design, is intended to be a minimum safety net of terms and conditions, and that the scheme is intended to encourage parties through enterprise bargaining to develop more beneficial or generous entitlements that reflect the circumstances of individual enterprises, and that must be taken into account. And of course, finally, the NES is supplemented or reinforced, if you will, through a much more comprehensive, broader workplace relations system. That includes obviously the provisions of the Fair Work Act, but also discrimination law, workplace health and safety law, etc. And that must also be taken into account by this committee. Now, I think our view, or one of the central views, is that the committee should be particularly mindful in conducting this review of the need for stability in our workplace relations laws, and particularly in the safety net. Stability is a crucial factor in driving compliance with our workplace laws. Also, that that consideration is particularly important when we take into account the waves of changes to our workplace relations laws that employers have had to grapple with over recent years. In saying that, we don't suggest that this committee shouldn't try to identify sensible improvements in the NES, and indeed we've identified a raft of those. But the point is we ultimately come to the view that you don't need to recommend any radical expansion or contraction of the NES entitlements. As I said, we've identified 35 sensible, modest and targeted improvements. I won't take you through all of that detail, but just to amplify some of the key propositions, we've said that it's really crucial that this committee grapple with the unworkable notion of the requirement to provide a full rate of pay in certain contexts where that just can't be readily or accurately identified. We think that the NES should look at comprehensively regulating annual leave, given that there's an inconsistent approach to the treatment of that in awards, and in various respects the treatment is unclear and somewhat incomplete. We do think it's time to address the obviously complex patchwork of inconsistent long service leave entitlements. But I think we would emphasise in that context that what we need is a balanced and fair approach to developing a nationally consistent scheme, not just a levelling up to the most generous or onerous element. And we've suggested an alternate approach as a modest first step towards that of letting parties deal with long service leave through enterprise bargaining or permitting the cashing out of long service leave, which are propositions that have obvious merit. We think that there's also a need to deal with the obviously impractical prohibition on terminating employee until you've paid them all of their payment in lieu that they're entitled to under the NES, and we deal with that in some detail in our submissions, and we attach some correspondence we provided to the Minister. Obviously, the current provisions made a lot of sense when you were paying people in cash on their last day. They don't make a lot of sense when you're dealing with the standard practice of providing termination payments through an EFT transfer. We've also proposed some sensible changes around the complex rules to parental leave, around public holidays. And then perhaps our most novel proposition, we've suggested that the NES should include a mechanism enabling the use of annualised wage or annualised salaries, which is an arrangement for smoothing people's pay that is desired by many employees and is deeply beneficial to workers, but which is notoriously risky now from an employer's perspective in light of certain federal court cases involving the Fair Work Ombudsman, Coles and Woolworths. I won't take you through the rest of the detail. I just urge the committee to grapple with the submissions, though, and happy to answer any questions.
Thank you very much for that statement and for your submission. There's a few things I'd like to sort of pull out there, and I'd also like to ask you for your perspective on some other recommendations or ideas that have been put to the committee thus far. So I'll start and then I will throw open to my colleagues here. I think the issue of long service leave is something a lot of people are looking at improving in terms of that's come through very strongly in a lot of the submissions. You speak of sensibly harmonising that. For the purposes of today's hearing, would you mind going into some detail about what that might look like?
I suppose the harmonisation of long service leave is unfinished business in relation to the shift towards a national workplace relations system. But the reality is, we do have different schemes in different states, and when you speak to large organisations operating across state borders, it is consistently identified as one of the biggest compliance challenges because you have these different entitlements, and also many of the provisions are quite archaic. They were drafted a long time ago. There are things like an absence of cashing out of long service leave that could be dealt with. But I think the committee needs to be mindful that many businesses just operate within one state. And so what we wouldn't want to see is a harmonisation that results in simply cherry-picking the most generous elements of each state scheme in order to come up with one approach. So, I think some of the other submissions have dealt with some of the detail, but, South Australia is considerably more generous than other states. We think that a sensible balance should be struck. Ultimately this will need compromises from all sides, but it is time to at least start the work on exploring that. It's not going to be easy, but we think there should be some consultation around whether we can explore that. But recognising it is hard, that's why we said that as a modest step towards that, permit the cashing out of annual leave and permit enterprise agreements to deal with, so that parties can themselves work out how they amend the state schemes.
Thank you. And, again, on questions of leave and paid parental leave as another category, you recommend in your submission that there should be a redraft in full of the paid parental leave provisions. Do you mind detailing that a little bit more for us too?
I think on any assessment, that part of the Act is one of the most complex and confusing. I mean, our submissions point this out, but they go on for pages and pages, and they include a raft of explanatory notes and so forth. The idea that lay people are across that is obviously debatable. I think, we haven't tried to redraft it. I think it's just clearly fertile ground for a complete reassessment of the way that that's articulated. And partly that's because it's developed in a piecemeal way. As I've said to you, the NES has not been set in stone. It's evolved. And one of the particular areas it's evolved is in parental leave. But because of that piecemeal development, it's quite complex. You keep sort of sticking some extra provision on the back without necessarily reassessing the whole. So I think, we need to just look at how we can recast that in much simpler terms. There's substantive changes as well that we've put to various things, but we just need to seek some simplicity in the way it's actually articulated. Even for lawyers, it's a nightmare when you have to explain this to people. It's always a case of opening the Act, going back through it and trying to refresh yourself.
I think on that point around, lawyers and interpretations, we heard from Alira last week at a hearing, and one of their recommendations is to really clarify some of the language to assist in ensuring that interpretations are consistent with the intention of the NES. I just wondered if you had any thoughts on that and how your members might approach that kind of recommendation.
Look, I think the clearer language is always necessary. I mean, we've tried in our submission to identify some specific areas of clarification. I mean, I think often, the legislation does reflect the intent, but it's confusing to people, is the simple point we're making. And in relation to parental leave, it's just too long. Like, it is ridiculous that our rules around this go on for so many pages, and it's a fiction to think that people are working through the legislation and understanding it. I'm not sure if it will.
Thank you. And my final question before I will invite my colleagues to ask a question too. I note that you suggest that the Fair Work Commission may have a role to play in examining the NES, and obviously mention, and we all understand that the nature of work has changed since the NES came into effect, and that we all require stability for it really to function at its best. We've heard some proposals for regular reviews of the NES. I wondered if you had any thoughts about that.
When you talked about a role for the Fair Work Commission, I think I'd emphasise the Commission has a role. The Act is set up specifically on the assumption that the Fair Work Commission will develop terms that supplement the National Employment Standards, that they provide terms and conditions that are appropriate for the category of workers covered by awards and employers covered by awards, or that provide industry or occupational specific context. And it has served that role as really the incubator of the development of supplementary entitlements beyond the National Employment Standards. To give you some perspective or some context, family and domestic violence leave, that evolved through the Fair Work Commission. I was the advocate in the two test cases that were about that. It developed as unpaid leave, and then it developed as a paid leave entitlement, and then ultimately made its way, in both instances, into the Act. But it's really important that the Commission plays that role, because it enables the Commission's expertise to be brought to bear on the development of these entitlements, and really quite robust consideration of issues. In those sorts of cases, there are vast numbers of witnesses that give evidence. Experts, lay witnesses, employees, employers. There are detailed submissions. The amount of ink that is spilt is quite astounding, and there are weeks of hearings and so forth. It is important that the Commission deals with the development of entitlements rather than, respectfully, these sorts of processes that are done in a much more expedited way and without the benefit of formal evidence being taken and tested in the usual way. So the Commission has an ongoing role to play in that, and we think that that should be carefully weighed by the committee before it suggests any sort of radical reassessment, because the Commission can also balance the complete raft of obligations that awards and the safety net, including the NES, provide on employers in coming up with a fair and reasonable outcomes that weighs all of those considerations. So I think that is the important role for the Commission. In terms of reviews, yes, it's timely that there be reviews of the NES, but make the point that the NES has been updated many times since it was first made. Our submissions go through and point that out. And, of course, the reviews need to be weighed against the importance of stability. You know, when you are constantly changing our workplace laws, as we have been, it not only imposes a very significant burden on employers, but it undermines compliance. You know, when we're changing the rules all the time, it is unsurprising that people are confused as to what the rules are. So, you know, yes, it is timely to sort of ensure our laws aren't set in stone, and the NES is part of that, but that needs to be weighed against, you know, the need to ensure that any review is rigorous and not resulting in unjustified or unnecessary frequency of changes.
Yeah, thank you. I also just taking into account, you know, your comments around the way some of these entitlements have evolved in a piecemeal fashion, how we then make sure that there is an avoidance of that if that has created problems, and, you know, having processes may assist.
So I think that yes, it is sensible to have an ongoing review of these things. I mean, parliamentary processes are often robust, and changes are made to legislation quickly in the context of contest. So it is sensible to have an ongoing review. I think the point we've made is that while we, have emphasised the important role that the Commission plays, I think sometimes it is worthwhile taking a comprehensive view of how the awards have evolved also in a piecemeal way, and the NES. So we've pointed out annual leave. I mean, the reality is that through successive cases, the annual leave provisions in awards have changed and evolved. I'm not sure they deal with all of the issues that the legislation assumes will be dealt with through awards. And, of course, the power of the Commission is in various ways constrained in terms of what content it can include in awards. So if you look at annual leave, there is a real problem now around the impossibility of undertaking long-standing practice of shutdowns. And what that I mean is there is, in many industries, a long-standing practice of shutting down for a period so that employees can simultaneously be placed on annual leave, so that is all taken at the same time. It minimises the disruption of the business. But there's a requirement that if you don't have leave, you need to put that employee on unpaid leave. Now, the Commission's ultimately found that it can't do that through the award. So we have this problem. We have annual leave. It was dealt with through the Annual Holidays Act in New South Wales comprehensively since 1944, if memory serves. But it dealt with shutdowns. The legislation was well understood by industry. We can deal with these things comprehensively, and I think a review to look at how things have evolved, draw on the work of the Commission, but then update it would be very sensible. And in saying that, we're not arguing against an ability for, a flexibility to be retained for employers and employees to agree on changes through enterprise agreements, but we nonetheless could step back and through a review look at how we can simplify the way our system's evolved.
Thank you. Are there any questions from colleagues here? Yes.
Hi. Sorry I was late, first of all. Can I just check, you've made lots of recommendations about what could be simplified in particular. Do you have a view as to from which changes you get the greatest productivity dividend? Have you looked at it through that lens?
Yeah, I think a lot of our changes are intended to simplify things in terms of removing the burden on employers. So, I just talked about annual leave.
Yes.
That is sensible because a lot less time would be spent. I'm not sure how much of them would necessarily, in granular detail, result in specific productivity improvements apart from just relieving people of that significant burden. That's the nature of the national employment standards. But I think the benefits of simplifying and removing some of the complexity shouldn't be sort of underestimated. A lot of time is spent trying to navigate the minefield of workplace relations laws, and anything that could be done to assist employers would greatly benefit the economy.
And you said that you felt that there was a risk in terms of compliance because it is just so dense and unnavigable that we're now at real risk of employers not being compliant. Do you have any feel for what percentage? Or what?
If you look at our workplace relations system in entirety, I think an overwhelming majority of organisations would be non-compliant with some element of it. There is an air of unreality around our system in the sense that the rules have been developed that people know cannot be complied with, that are not complied with. You know, I talked about annualised salaries, not an established part of the NES, but we know our record-keeping requirements are completely out of step with modern workplace practices. And we know that there's a mechanism that enables awards to deal with annualised wage arrangements, but because of provisions in the Act, it needs to include all sorts of detail around record-keeping reconciliation that the Commission itself has noted are unlikely to be complied with in practice and which undermine the benefits of annualised salary type arrangements. That is an area that is screaming out for reform because employers, particularly where we see people working from home and so forth, cannot comply with these requirements. Now, we talked about productivity a second ago. One of the areas in the NES is public holidays. There is this farcical requirement that you have to request an employee every single public holiday to work on the public holiday. There is then a limited capacity to refuse, which means in reality there is a default capacity to actually require, where it's reasonable to require and not unreasonable, and would be unreasonable for them to refuse, to require them to work on public holidays. But why we go through this fiction of having to make a request, even in industries where we know work on public holidays is a regular feature. Think about, you know, emergency type services operations that need to run every day of the year. Now, surely we should be able to make people aware through their contracts, through their policies, that there's going to be this reasonable expectation that you are required to work on a public holiday as part of your engagement. Doesn't mean you shouldn't have a right to refuse where it would be reasonable, but at the moment the Act sets it up so that people who do that, who are forthright about that, are in breach, unless they go through the fiction. So that is, you know, in terms of productivity, it would be much more sensible to give people a clear upfront awareness of what's going to be required so that they are available and so forth, and we're not exposing employers to these technical breaches. But yes, in terms of percentage, there would be a significant number of employers that are in breach. We point out in detail this provision around notice of termination. You know, under the Act, you are prohibited from terminating somebody until you've paid out their payment in lieu of notice. There's a federal court case to refer to that suggests that that applies to all NES entitlements. We think that's wrong, and that it maybe there's a gap in the legislation about when you're required to pay out NES entitlements. But the point is, obviously, for all the reasons we've pointed out, there are times when you can't give somebody their final pay on that day. You know, especially if the decision's been made last minute, you don't have payroll there, etc. And we know people like being paid by EFT. We are past the time when we handed people an envelope of cash on their final day. Now, obviously there is merit in updating this so that people could be paid, you know, in their next pay period or some later point in time. And we've gone through in quite a bit of detail explaining that issue, and we noted that it's supported by the other peak employer groups.
Thank you. I believe we've got Ms. Fernando with a question on the phone.
Thank you, Chair. So my question is, thank you for being here today. Your submission argues that the NES should not be expanded and that the inquiry should focus on technical fixes, simplification and reducing regulatory burden, but the NES is not meant to be the basic safety net for workers. So my question is, how do we make sure that simplification does not become a way of reducing practical protections for workers, especially workers in insecure jobs, shift workers, and those trying to balance caring responsibilities, such as parents and children that are caring for their elderly parents, or those, and what safeguards would you support to ensure any technical changes do not burden the minimum floor? Thank you.
Yeah, well, we've been very clear. We're saying that there shouldn't be a radical expansion or contraction of the national employment standards. They're actually designed to be the minimum, just to be clear, set of terms and conditions. That is all. We've proposed a range of practical measures to improve them, which we don't think unfairly undermine entitlements. We've not called for any unfair undermining of the national employment standards, but there are known problems in the legislation that we need to grapple with that should be fixed. And we're not suggesting in any way that the situation of the workers you've referred to be unfairly adversely changed. I think it's important to appreciate, you talk about insecure workers. There have been dramatic changes to the legislation to enhance entitlements of casual workers, if that is who you are referring to. You talk about workers with carers' responsibilities. I think it's important to understand that the safety net in the National Employment Standards was just dramatically varied to increase entitlements, including providing quite radical new powers for the Fair Work Commission to arbitrate disputes around requests for flexible work arrangements, which may be accessed in order to utilise caring responsibilities. And of course, we do have a comprehensive set of workplace laws beyond the National Employment Standards that protect people. It needs to be understood by this committee that there are unfair dismissal laws, there are discrimination laws. It is not the case that in simplifying the NES we're suddenly leaving workers exposed to some form of unfair treatment. It simply would, to suggest that would be completely out of step with the realities of the way our workplace laws work. So again, we're looking at how we simplify this, because if you want to enhance compliance, we need to make it possible for parties to actually understand our rules in relation to the way work is undertaken. That, I think, is one of the most powerful ways we could actually help workers, is by making our system realistic.
Thank you so much, Mr. Ferguson. So I'm a member for Fowler here in Western Sydney, and actually there are so many things that I could ask, but we don't have the time. You mentioned about the awards evolving in piecemeal ways, and that, you know, you cite the parental leave being very complicated or leave complicated, and so people can't really, find to comply. I visited last few weeks a lot of businesses locally, manufacturing, which is one of the largest employers here in Western Sydney. And they've cited that they didn't even know that NES existed, right? The National Employment Standards. So they didn't understand what that was, and I personally didn't understand what it was until I actually am part of this public hearing. What do you think has been available to, especially in multicultural workforce, that the National Employment Standards is available for them to understand? And as you've described, there's so much there that is really complicated. So for a multicultural community, does your industry also know or have any fact or data around that in terms of the NES and its understanding within that cohort?
Yeah, I can't point you to any specific data around the understanding of the National Employment Standards in diverse cohorts, even in the manufacturing context. But certainly, I know from my experience that when you work with manufacturing employers, they often have diverse workforces, and they go to significant lengths to try and explain, conditions and entitlements. But you're often explaining enterprise agreements, awards, the NES. The burden on employers to be able to do that is complex, right? And particularly where they might have a diverse, multicultural workforce. I think that measures, by organisations such as the Fair Work Ombudsman to potentially provide educational material in different languages and so forth could assist. But again, I keep coming back to one of the key ways we can assist drive compliance, both through awareness by employees and by employers, is maintaining a level of stability in our workplace relations laws. I'm going to come back to the Annual Holidays Act and talk about it's a very complicated piece of legislation when you read through it. But for many decades, there was stability in our leave entitlements, and there was an understanding that as a result permeated through industry around what the rules were. You didn't need to keep checking the rule book and checking whether or not it got amended in the last term of Parliament, because the rules were consistent. Once employers did the work to make sure that they were implemented and that their employees were told about things, they didn't need to keep reassessing it At the moment, you almost need to be on a constant watching brief as an employer for changes to our system, just to stay on top of your compliance obligations. So when you ask about multicultural employers, I think it beggars belief to think that somebody with language difficulties who is just trying to get through their day is able to keep up to date with all of these changes or to wade through the pages and pages of rules just around parental leave.
Thank you. Unfortunately, we're out of time for this slot, but we really do appreciate your participation today. And you'll be sent a copy of the transcript to request any required corrections, and we may be in touch with further questions if that's okay. Yeah, thank you very much. Really appreciate it. Have a good day.
Thank you.
Good morning. I now welcome the witness from Youth Law Australia to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
Thank you. My name is Anastasia Coronio. I'm a senior solicitor and national practice lead in employment law at Youth Law Australia.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you very much. Well, I know that the committee will have seen our submission from Youth Law Australia. I know that the committee will have read this. I assume that the committee has read this. I think that just hearing from my colleague from the Australian Industry Group just briefly, just before me, that sentiment of having a good relationship between employers and employees is really where we are coming from with our proposal, which is to establish clarity in an employment relationship from the very outset. Having Youth Law Australia over the last 5 years, I've personally and with my colleagues assisted about 1,000 people a year, 1,000 matters a year of young people under 25 who have one employment question or the other. And it became apparent to me very early on that the absence of any consistency of approach to the start of an employment relationship was the source of a great number of problems, misunderstandings and grief. You know, it really, in terms of expenses and to the taxpayer and to the economy, it became apparent to me that this was a really serious number one problem. The number of people that we have seen that don't have a contract of employment or have a contract of employment but cannot understand it without having it to come to us and say, can you help me? The number of people who have a problem years down the track where you say, can we see your contract? Oh, I don't have one. Or there's a text messages, or I had Facebook messages or something like this, where it's impossible to work out what was this working relationship? What was established? And then services like ours, a nationally accredited community legal centre, it takes a free legal service, taxpayer funded, to try and unpick what should have been really apparent from the outset. What was this employment? What was this relationship? And that's just our service, 1,000 people a year. That's just the ones that come to us. And then you see that the Fair Work Ombudsman's reports, nearly $500 million every single year in underpayments, and that's just the ones they've caught. And this is it's so difficult for people to work out what they should have been paid, and then to rectify with their employer. So the ones that where the Fair Work Ombudsman has recouped these amounts must be just the tip of the iceberg. And in terms of lost revenue and standard of living, you know, the potential impacts of this are huge. And it seems to me, when I first had this idea, I thought, oh, if it was so simple, it would have been fixed already. This is just to have a simple contract of employment in the standard terms. Nice and simple. Like you see even in the awards now, they're standardised. So you know where the classification term is, you know where the termination term is. It's got a standard pattern. Or a residential tenancy agreement where it's recognisable. You know what you're looking for, the clauses are there. In employment world, it doesn't exist. This pastiche between common law employment and now statutory regulation, they're not mixing at the fundamental level, which is at the inception of an employment relationship. I thought, just coming back to my point, I thought, well, this is such a silly idea, Anastasia. You know, if it was so simple, somebody would have done it. And we started to look into it. And in fact, it has been the subject of academic commentary. And looking through the submissions, I haven't read through all of them before this committee, but there are several that are aligned. JobWatch, I could go through them if you like. JobWatch certainly has something like this, and we've endorsed their submission. They've endorsed ours. They're a community legal centre. But I think the main one that is interesting is before the committee is the academic article by Sarah Charlesworth and Ian Campbell. And it was their idea that when we actually put a paper to Treasury in the white paper, the employment white paper a few years ago, and we found that this idea of having a standardised term of working conditions was an idea that they had already proposed. And so that gave me some courage to think, well, it's not such a silly idea. Why hasn't it been done already? It's not so novel. It's been done in the UK, it's been done in the EU, and it's been done in New Zealand. So there is a model, and I've thought a bit more about it. How could this actually work? And it's also reflected in Charlesworth's and Campbell's submission that the statement of terms of working conditions be given at the inception of employment, and then annually after that, to coincide with the annual wage review in July, so that it catches people when they've moved to a different classification, or they've become part-time, or their pay rates increased, or so on, so that or the pay rate's gone up, or they're another year older, so they should be being paid more. So, you know, obviously, our organisation, we're dealing with people who are under 21 a lot, so they're being paid often under awards, and they've been paying junior wages. And so add that complexity, and people really lose track of how much they should be getting paid quite easily. I mean, I could go through just briefly the other submissions that I saw that would support this.
I think we could also ask some questions if you
Sure, yeah.
need to allow the committee to do that as well. I think it has, as you note, it has come up quite consistently across submissions, this question of a change from the current Fair Work information statement to something else, including a written employment contract. And on that, I guess I'd be really interested to know what core terms does Youth Law Australia believe must be mandatory in a standard form?
Yeah, I noticed that JobWatch has also given some of those. Charlesworth and Campbell have also given some of those. We've given some as well in our submissions. But I think that the most important ones, to have it standardised, is the most, so it's recognisable. People go job to job and they can identify, oh, hang on, where's the clause about my classification, or where's the clause about termination? Because at the moment there's such a myriad of approaches. It's not easy to find where are these terms, where are the sneaky things tucked in. where are the unenforceable terms? And there's lots of unenforceable terms in these types of contracts. And as Treasury reviewed, I think 2 years ago, they found that the fact that people need to come to a service like ours to find out whether there's a term in their contract that's enforceable or not is a big drain on productivity. So people should be able to get a contract that's simple, really simple, in 2 pages in a standard form that they can understand. There are the important working terms. And if it refers to an award, and I understand awards are complex and they can change regularly, but even to identify what the award is and the classification and the nature of the employment, then at least that there's a flag to, okay, now we know where we're looking in the award, rather than also then be duplicating the award needlessly. Because I think that you want to make this easy. You don't want to necessarily duplicate the whole award. But I think it was a LERA submission talked about 20% of. I think it was actually Campbell and Charlesworth's submission that said 20.5% of employees have their pay set by awards who are disproportionately engaged in industries where insecure work is rife. So that's our commonality. That's our clientele. Retail, fast food, under 25, generally speaking. So a lot of our clients are covered by the major awards, and so. But often it's not stated in the contract, if there is one at all. So it's not easy sometimes to work out, is someone covered by the Hospitality Industry Award, or are they covered by the Restaurant Industry Award, or are they covered by the, it can be difficult to work out sometimes. And so I think you asked what terms should be in the standard form contract. I think award coverage, classification. So what level are you going in at, so that people can check, okay, I'd hear a level 2 duty, so does that read what I'm doing? Or it says, often we see a contract that says, oh, you're introductory, but people stay on introductory for a long time and they don't realise, actually you should have gone up a grade. So some things that they can mark, they can check the award, does this sound right? Is this reflective of what I'm doing? So classification under the award. And this is really important, the nature of employment. We see this getting wrong all the time. Are you a casual? Are you a part-time? Are you full-time? And the classic example is people say, I work part-time, and in the vernacular people often don't know that part-time is specifically defined within an award, and it necessitates a written agreement. And a lot of the time people don't have a written agreement. There's no guaranteed hours, and people think, oh, I work part-time because I don't work full-time. But actually they're casual, and they should be paid a casual loading. Many, many, many times we see people speak to somebody about something unrelated. I've been dismissed, okay, or something else is pulling at work. It could be anything. Often it's when things are at the pointy end of their employment, when things are going wrong. And then we'll say, well, let's see your pay slips. Oh, my hours changed all the time. They'll say, I was paid a flat rate. I don't have any records of when I worked weekends. It's impossible to unpick. How long have you been employed? A couple of years. So they've come to us because they're protected from unfair dismissal, or things are at a tipping point in their employment relationship, and then to go back and say, well, actually, you should have been a casual because you haven't got any guaranteed hours. But how are you going to prove what you actually worked when no records were kept? So it's impossible to work out the underpayment. This happens countless times. And so I've listed the award, the classification, and the type of engagement. Is it part-time, is it casual, or is it full-time? I think they are the main three.
Great, thank you.
Yep.
I'll just see if any of my colleagues have questions that they would like to ask. Ms. Fernando, yeah, great.
Your submission makes a compelling case that many young workers are entering jobs with little or no understanding of their rights, often without written contract at all. In practical terms, how is this gap enabling, sorry, I'm trying to read my own writing, systematic underpayment and exploitation, and why hasn't the current framework been able to prevent that?
Yeah, I think I've started to answer that already in some of the things I've said. But if you don't, and this is also reflected in some of the other submissions before the committee, if you don't know your rights, if you don't know what what you should be getting from the outset, then you can't enforce them. And I think the submission from AYAC, from Australian Youth Affairs Commission, talks about even international law, which is something that the Fair Work Act needs to give credence to within its obligations, that a child needs to know their rights. And so if you don't know what you're going to be, what your engagement is, you're very, very susceptible to exploitation. And also it's a contravention of international law. So in order for the Fair Work Act to give proper regard, take into regard Australia's international obligations, it needs to also enable a young person to know, in our case, I mean anybody, I think, arguably, but to know what the engagement is at the outset of their employment engagement. Because if they don't know, there's a great risk of being, what's the issues? They're at great risk of being underpaid. They're at great risk of not knowing what they need to keep in order to be able to enforce their rights down the track. So as you would know, as you may know, in order to, there are lots of protections in the Fair Work Act. Of course, a person needs to be, paid in accordance with the award at the correct rate, and Section 323 must be paid in full in relation to the performance of work. But then, and then there's all these record-keeping provisions and things like that, 536 pay slips and things like that. We see this breached all the time, and the Fair Work Ombudsman, is subsumed with complaints or notifications, and they cannot catch everyone, and they will refer back to us. And they'll say, well, we've tried to resolve this matter with your employer, but they're not engaging with the process. We'll refer you to legal advice. So they come back to us. And then we talk to them about, it looks like there has been an underpayment. You've been paid under the wrong award, under the wrong classification. What evidence do you have of this? Oh, I didn't keep any timesheets. Oh, all my timesheets are on deputy, they'll say. But I haven't got my access anymore, because I don't work there anymore. So they haven't got independent records. They don't know what they should have kept.
Yeah.
And the employer hasn't kept them. And the only way to get them is to go through a court process and then try and get discovery to get a copy of those records. Because the Fair Work Ombudsman won't get them. As I think their submission said, we look after 14 million workers. It's impossible for the Fair Work Ombudsman to catch them. When I say catch them, I don't mean in a pejorative sense, but it's impossible for the regulator to scrutinise at this level every single employee.
Yeah.
So an enforcement is notoriously difficult, even though there have been lots of movements to try and make it an easier process. Still currently, a person needs to go to a court, make a court application, most commonly the Federal Circuit and Family Court of Australia. They need to do it within 6 years of the underpayment occurring, and that there is still a lot of onus on them. So that, yes, it is meant to be a user-friendly system, but they need to, it's extraordinarily difficult still to navigate it. They need to serve on the employer. The employer may have now been in liquidation. They'll never get the money back, or they need to know, what are the other sections in the Fair Work Act? If the director was knowingly involved in the contravention, I should also name the director as a respondent, so I've got a better chance of increasing my chances of seeing this money. But people don't know that without coming to get legal advice. And then they have to serve the application themselves on their employer. They need to pay money to get an ASIC, when they even know that, to pay money to do an ASIC search to find out what is the registered address of the employer. Then when they're not able to do it, they go back to the court, and the court says, well, maybe we can find another way of effecting service, because they're not bound by procedural rules. But in practice, it is unnavigable for your average person.
Can I also, right, he's got a question.
Okay, thank you. Look, you've suggested that we need to have the written employment contract with basic requirements, which sounds like a really worthwhile reform. But if we take it a step back, young people very often don't understand what their rights are in the first place. How do we include some basic principles around the National Employment Standards and actually communicate that to young people before they move into work, so that we prevent some of these things occurring? Because if you go into any group of young people, say in a classroom, they don't know what the potential rights are. So what do we do to prevent and, well, to give young people better knowledge of their rights?
That's a great question. I know the Fair Work Ombudsman tries its very hardest to have a community engagement program, and they have lots of little snippets of things that people need to know. But the question is, especially with young people these days, where are they getting their information from? And our service has struggled with that. We have a website, but we're also now competing with Google AI and people finding, little snippets of, dodgybrothers.com on how to find their rights.
So what do you think the solution might be? I'm just trying to get to the point.
One solution I can suggest is for example, in the Northern Territory, as in partnership with the Northern Territory Electoral Commission, we have a program with schools, part of a program they call Democracy Dash, and we have 10 minutes with each group of students, and it happens twice a year in Darwin and Alice Springs. And I've calculated over the last 5 years we would have nearly covered every student at most schools in the Northern Territory, and we do a crash course, and we start with little multiple choice questions. This is Delilah. She's 18. She called in sick but still got paid. What sort of employee is Delilah? So they're getting them thinking, okay, she's a part-time employee. So with the little scenarios to try and make it as engaging as possible. And so, like I said, it's a crash course in employment law, and so people, have a little flag of when they go to get their job, somebody came to speak to us and there's different categories of employment law. They have a little worksheet and they have the few little questions that they need to answer. And that's just 10 minutes, 10 minutes. But that's a program that I've found really satisfying and effective and standardised, I guess. That's just one idea that we have used, but I think other places try and do versions of this. So there's the Young Workers Centre in the ACT, for example. We've partnered with them before. They have a schools project. They're affiliated with Unions ACT, and I think that's one way through the unions that people are getting this type of information. But I guess to me, the Fair Work Ombudsman's got all the info if people know to look there. But if people know to look there.
Yeah.
And just on the question about the Fair Work Ombudsman and their outreach work, and I note in one of your previous responses you indicate that there is that issue with record keeping. Do you have any views on what the Fair Work Ombudsman could do to ensure that employers understood their obligations around record keeping, so that when people come to your service, we're not experiencing the issues that you've described?
I think it's hard for the Fair Work Ombudsman because they already have these record-keeping requirements, pay slips, for example. But in all my time, I've only seen the Fair Work Ombudsman issue a fine once, and that was only in a case where it was so obvious this person was in an employment relationship, there was an employment contract, there was a bank transaction, there was no pay slip, and they issued an infringement notice. But that's the only time I've seen it, and I just think that their resources are inundated. So in terms of trying to come to the point, there's already, the Fair Work Act's got all these rights, the entitlements. The employer must keep these records of pay slip, must provide a pay slip within a day of payment, must. Okay, but it's still not happening, and the resources of the Fair Work Ombudsman are too slim to be able to issue infringement notices or come with enforcement action every single time. So bring it back a step. If it's already, if it becomes like the Fair Work info statement is already something an employer has to give, it's not too difficult for an employer to give that. I haven't seen too many cases where that's a problem that they haven't given it. If it now becomes an NES expectation that a basic contract in a standard form, and that's really important, I impress on the community, it must be in a standard form, so that it's, for the reasons I've already said, any contract is not what what we're asking for, because of the complexities and the what am I looking at type of situation. But if it becomes standardised, that everybody knows to come to expect that, and people tell me I didn't get pay slips. They know already it's an expectation because it's become into common knowledge, and I think it would easily become into common knowledge that people should get a contract. In fact, it's often a misconception that people say to me, "Oh, I haven't got a contract." I said, "Well, that doesn't matter, So people think already they should be getting a contract, and their red flags are up when they don't have one. So I don't think it's too much to to become a part of that normal workplace cultural expectation. I get paid, I get a pay slip, and I have a standard form contract. Just like with the residential tenancy, people know there's a standard form agreement, and they can easily identify that, you know, if they get something that looks dodgy.
Yeah, thank you for that. And we do have a few more minutes left, so Ms. Fernando.
Thank you. So one of the questions is, what are the most common types of queries YLA receives regarding employment contract confusion and disputes? What are the common outcomes you have seen from these misunderstandings?
Common outcomes is they might leave, or they might put up with something that they know is not quite right, but it doesn't seem to be the time to challenge it. But when the time comes, they leave. They leave because they realise they can get something better somewhere else. So it's about, to me, creating that culture or that expectation, so that it's not this constant economic drain of people, you know, not getting paid enough and trying to go somewhere else where they might get a better go. So in a best case scenario, somebody will come to us at the outset of employment. I had this just last week. Someone will say, can you have a look at my contract and tell me if it looks legit? And that's very rare that people will come to us at the outset and say, and ask that at the beginning. It's usually at the end, when this didn't work out for me, and I've got a bit of sour grapes, and can you just go back and, you know, tell me, you know. But in that case, and this is indicative of, I think, the types of contracts that are out there, it says employment contractor arrangement, and it's got this mishmash of terms that talk about employee and talk about contractor. It doesn't refer to the award, but in this case it was real estate. It was going to be an entry-level, commission-only payment, which is contrary to the award, and this is just the ones we see. We're a tiny little community legal centre where me and one other solicitor are working in employment law. That's it. And that's just the ones we see. And so people will, if they haven't come to us, will start working in this sort of situation, eventually feel ripped off and maybe go somewhere else. But it's usually far too late for them to say, well, actually, even though I signed this agreement, I didn't really mean it, or it wasn't legal, and so I want to unpick it. It's too hard for people. But sometimes, best case scenario, they might get our help to write a letter to say, look, this person was engaged. It looks like it was a sham contracting arrangement. We'll make a complaint to the Fair Work Ombudsman. If you don't pay them as an employee at the level 1 real estate agent, or under the real estate award, for all their hours of work from the beginning to the end, and maybe we'll get an outcome where they'll say, okay, we'll pay you, or we'll pay you something, because they don't want the attention of the regulator. Sometimes they don't care, and so then the regulator will get involved, and the Fair Work Ombudsman will tell the client, they weren't wanting to cooperate. So go back to Youth Law Australia and see if you can take enforcement action. This happens all the time. All the time. And so then we'll try and help them. But like I said, we're a really little legal service. We'll try and help them. But the resources for us to actually represent somebody in the small claims jurisdiction are quite enormous. People are going back and forth. The registry told me this, the registry told me that. You could spend all day, you know, just looking after one matter in the enforcement jurisdiction. Oh, sorry, that's another question. Enforcement is also impossible. You might get an order for payment, and the employer just won't pay. And then taking enforcement action, impossible. And I think I won't try and venture into territory that I'm not well versed in, but I think there's been lots of reports about enforcement rates coming out of that jurisdiction. So does that answer the question?
Yes. Thank you very much. Really appreciate you being here this morning and providing us with so much to consider. You'll be sent a copy of the transcript and request any required corrections. And thank you once again for your submission and for appearing here this morning.
Thank you for the work you do.
Yes, that's right. Thank you. Thank you. Morning. I now welcome the witness from Martha Travis People Innovators to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
Martha Travis, and I'm the founder and director of Martha Travis People Innovators, and I'm here to sort of represent small to medium businesses from an HR perspective.
Excellent, thank you. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you, and thank you very much for the opportunity to put in the submission in the first instance and then to provide some further clarification. So, as I said, I'm here I'm not a lawyer, I'm not an employment lawyer, I'm here very much from a practical HR application perspective, particularly with small to medium businesses. I've worked in human resources for too many years, and over that period of time I've worked both in quite large corporate organisations, and now in the last nearly 7 years I've been operating my own consultancy where I provide outsourced HR services to small to medium businesses. In the context of the NES, I was working in corporate at the time the Fair Work Act came into being, and sort of faced some early challenges of applying that to workplaces and etc., and understanding the new laws, and have seen over the years, obviously, the various amendments and iterations of the NES. Our perspective is the fact that, similar to the AI group, is that the NES is designed as a set of minimum standards and is a safety net for employees, and should be therefore a guide for employers as to how to legally and minimally engage their people. But it should be simple and not so admin burdensome as it really is in lots of places. It could be simplified in some ways, but we also feel that this isn't the opportunity to extend or expand the provisions of the NES necessarily, but to simplify and to clarify its application on a day-to-day basis.
Well, thank you very much. And you know, we've heard a little bit both this morning and through when we've seen in the submissions that there is that complexity in a number of areas, particularly coming out around long service leave and paid parental leave, I think. I'd just invite your reflections on, well, all the areas where it's complicated, but particularly those two as recurrent areas of concern.
Certainly. So I think, you know, long service leave is pretty obvious in the fact that it's state legislated, and therefore if you have, so for example, one of my clients has operations in New South Wales, Victoria, WA and New Zealand, and so for them juggling the various employment jurisdictions, and they've only got 40-odd employees. So they're a small business, and it's very challenging, and, they don't know which bit of legislation to look at when, and in one case they had someone who lived in New South Wales but had been staying in Victoria to do a job, and so which bit applies, which public holidays apply, should they be accruing long service leave under the, Victorian Act, etc. So there's lots of iterations of things that come up that, of course, the legislation can't deal with every iteration. I get that. But it's about, helping provide some clarity around what to do when these anomalies arise, and what's the intent. And I think sometimes that's the bit that's lacking for the NES, is what's the intent of this clause, so that we can then say, okay, then if that was the intent, how do we manage this particular situation so that the outcome that the clause was intending to address is actually addressed.
And on that point, how do you think we could clarify that intent? Because I think the ALIRA submission and their evidence last week in Melbourne went to this idea that sometimes interpretations and intent do not align, and it would be helpful to try and have a process to get that alignment. What do you think that would look like?
Yeah, look, and it's not a simple answer, I don't think, because, you know, that's why we have case law, et cetera, and, you know, one of the things, and I'm slightly deviating, but I will come back and answer the question. I mean, one of the things I've always enjoyed being part of award amendments to hear the conversations as to why we're changing a clause in an award, because that leads to intent, but it's actually kind of difficult on the Fair Work Commission website to surface some of that conversation to understand what were the union and the employer associations trying to achieve by changing this. What was the argument? So whether or not that some of the commentary around why we have the NES that's easily researchable for those people who want to find out intent, that would be useful. And I'll give you an example. Annual leave loading. The intent of that, as far as I understand it, started back in the 1940s, where employees who worked shift work and had access to overtime and penalty rates, the idea was so that they weren't disadvantaged when they took annual leave. So they would get a leave loading. However, leave loading applies to people even on salaries in some circumstances. You know, why? Why, if you're on a $85,000 a year salary, why would we pay you more not to be at work? That doesn't even make sense. So, you know, going back and clarifying what was the point of this clause, and therefore how should it therefore be applied sensibly to the modern situation. So, as I said, so whether or not there's a way to help people, whether it's an employer or an advisor like me, to surface some of that intent through easy research, that could be very helpful. I know the Fair Work Ombudsman tries to provide some examples of, you know, Sally works this many hours and so this is how she should be paid. More of that, whether that comes from the community and you know, there's somebody who vets it and makes sure that the examples that for example, I could submit 10 examples of situations that I've had to deal with in real life. Somebody vets that, makes sure that they believe it's compliant, that way of dealing with it was compliant, and then that becomes an example. And then we build it over time, like with case law, we build over time a library of examples that address some of these real life anomalies.
And you know, I think, you know, this is a really helpful process for the community, and I think for stakeholders to start ventilating some issues and ideas and concerns. What would your position be on whether we should more regularly look at the NES, understanding, of course, we want to get the stability, and that's important, I understand, for everyone to know what obligations and entitlements exist, but understanding too that we have evolving workplaces that I'm sure you see all the time.
Yep. Look, I think, you know, what's it been? 2009, so... Yeah. You know, it's been a number of years since we've had a formal review, so obviously more frequently than that. I would potentially say, you know, every 2 to 3 years, but having said that, certainly when amendments come through, I think that's really important. And I think that's kind of some of the issues that we're seeing in the NES application now, is that there's been amendments to the Act that have flowed through to the workplace but haven't necessarily been properly addressed or thought about how those two things interact. But so certainly every time there's an amendment. So. Okay,
thank you very much. I'll just see if my colleagues have some questions. Yeah,
thank you so much, Mrs. Travis. You worked, you know, with a lot of small to medium-sized businesses. I'm just very curious. I represent a very multicultural community here in Fowler, and I have visited many of those non-English speaking employers and employees. Both are also trying to navigate through the workplace changes, laws and legislations that we bring down. And a lot of them have not heard of NES, neither have I. So have you, do you come across, when you talk about, you know, the difficulties, you know, for employers, have you dealt with multicultural, small, medium-sized businesses, and is that some of the issues for to comply with a lot of our legislations?
I have. What I will say is that I also choose not to work with clients who are unwilling to comply with the law. So, because that puts me and my reputation at risk. So I've had clients come and go at times who are multicultural because they, quite frankly, refuse to comply with employment law because they are comfortable having cash payments on the side and, you know, other bits and bobs that we won't go into. And if I say to them that, you know, unless we address this, I can't continue working with you, they'll sometimes say, well, I'm not going to change. And it's like, okay, well, we'll part ways here then. But I think, look, education is the key to all of this. And, you know, I was listening before to the youth law representative and, you know, I agree that young people coming into the workplace often are completely clueless about their rights in the workplace. And I've been banging on in my own life for ages about the fact that it should be included in the school curriculum, you know, how to fill out a tax return and just basic stuff, you know, what does an award look like and how do you work out what you should be paid? I mean, it's how we function as people. So why kids aren't being taught these basic skills at school, I don't understand. You know, whether the Fair Work Information Statement gets replaced, sorry, I'm deviating again, but the Fair Work Information Statement gets replaced with an online course that you have to do, or, you know, you apply for a tax file number and it triggers an information pack or a course or something that the person has to do, because there's also immigrant people who apply for tax numbers that are clueless as well, and that could address some of the modern slavery challenges that Australia faces at times. Anyway, to come back to your answer, I think there's a bigger issue in the sense that multicultural business owners often culturally have different standards with regard to all sorts of things around, you know, cash society and working in a sort of more off-grid kind of way, and so therefore, you know, I think there has to be a multi-directional education program for those people so that they can become aware. And again, what are the triggers? If you apply for an ABN, what information is being provided to you at that stage? You know, is there like a license course like you have to do for your driver's license? You can't even get your learners unless you do a theory course about the basic road rules. So can you even get a business number? Can you apply for an ABN without having to at least have some basic information about what it means to be a business owner? Even if you're a sole trader, there's some minimum stuff that you're going to need to know before you open a business. So I think there's multi-layers of education that we could be doing across society to help with this overarching issue. So,
thanks, Chair. Thank you for your contributions this morning. Just on the point around clearer guidance on what constitutes reasonable evidence, particularly when we're talking about people exercising their right around personal carers leave. Could you just talk a little bit about the evidence, what small businesses that you're representing usually accept, what are they actually questioning, and what clearer standards would help small businesses in that space?
So let me preface my answer by saying that I personally have witnessed an increase in the taking of personal leave. So personal leave balances. People used to not call in sick, right? So back in the day, you didn't call in sick unless you were actually sick. There's been a strong movement towards using every skerrick of every bit of leave that you've got available in your personal leave balance. There's a trend towards that, and it's escalating every year that I'm seeing. Just the other night, I wrote a letter for a client. They've got an employee who has, in the last 12 months, who has been absent on personal leave-related leave for 30 days in 12 months. And 25 of those days were unpaid. So excessive leave is becoming more and more of a challenge. So therefore, going back to your question, the evidence that is provided becomes more important because a small business who's somebody sick and doesn't turn up, if that is one person who does a job and they're constantly, because that's the word that an employer would use, constantly sick and constantly away, that becomes really hard for them to manage in their business, because they don't know they're not turning up until 5 minutes before their shift or whatever. They've got to find someone to replace it, blah, 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 blah. So the evidence becomes quite important, and being able to say, we won't pay you, so almost a threat, yes, but we won't pay you unless you can provide some reasonable evidence to support the reason for your absence, particularly when you've had excessive and frequent absences from the workplace. So then it begs the question then of, I mean, there's always been a stat dec. You know, I worked in businesses where there was a stat dec regimes at certain sites, you know, where somebody was a JP and for, you know, $10 they'd sign somebody's stat dec without caring. So there's always ways of getting around stuff, right? So you'll never make it completely foolproof. But, you know, going to a chemist and paying $6.50 to say, I've got the sniffles and I don't want to go to work today, can you write me a certificate? Is that reasonable evidence? Because it's from a medical provider, it seems to be accepted in society that that's reasonable from a pharmacy. But I recommend to many of my clients to say that a certificate from a pharmacy is not acceptable. You need to go to a registered medical practitioner, not a pharmacist, and get a certificate that way. So I guess, you know, if we were to push the boundaries a little bit, and there's also, you know, the whole online thing, so you can literally sit at home and apply online for a medical certificate, and you pay $7.95 or $10 or whatever it is for a medical certificate without even leaving your home. And you tell that doctor, and unfortunately they're registered doctors, and I say that unfortunately, but they're relying on the information that the patient provides them to then determine whether or not somebody's sick and can be validated as being away from leave. So, yeah, they're the challenges. I've also seen some AI-generated medical certificates that we've been able to determine were not legitimate. And I mean, that's pretty easy if you get a falsified or AI-generated medical certificate. But again, it's the burden around that. You know, it's the having to check on it, to be managing all these things. You know, when you're a small business owner and you're trying to juggle 50 things, it's just one more thing to add to the list. And sometimes it's just easier to pay it because you can't be bothered, or you don't have time, or you don't get to it, or whatever it is. So it can be challenging.
Thank you. I think Ms. McKenzie has a question.
Hello, thank you for being here today. Do you have an idea of just how much time small businesses are spending trying to make sure that they are NES compliant in particular? And you've made a number of sort of recommendations. If you could do 2 or 3 that would actually really reduce that time, what would you go for first?
Yep, okay. I don't know from a time perspective, but I can probably sort of guess and say most of my clients are spending the value of about 6 or 7 hours just with me a month. And so therefore I'm helping them deal with not just specifically NES, but the gambit of employee matters, which somewhat touches on NES, whether it's, you know, performance management and the process of doing that, or whether it's a termination, or it's leave management, or it's I've got to do a pay point progression, or whatever it is. It's somewhat related to the NES. And then no doubt they've got the own time that they spend inside their own business, but I wouldn't necessarily be able to guess what that equates to. With regard to some changes, for me, leave is actually one of the biggest issues that takes up time for my clients. Annual leave, not so much, but you know, still also understanding around you know, whether they should. A regular conversation is whether they can direct people to take annual leave because they don't want to carry the liability. But as we know under the Act, they have to have at least 8 weeks of leave before they can be directed to take leave. And again, if you think about a business of 20 people, that can be a considerable amount of liability that they're carrying. We touched on personal and carers leave and excessive leave. And again, under the Act, you would know that until someone has had 12 weeks worth of unpaid absence due to personal injury or absences, then there continues to be a protection against termination. So there's very little. This employer that I wrote the letter for the other day, that person's going to have to take another 30 days of unpaid sick leave within a 12-month period before that employer can actually take action to terminate their employment for that reason. Obviously, they can look for other reasons, but we wouldn't recommend them to do that. So for me, and then we add public holidays and leave essentially around that. For me, they're the things that need attention in the NES. And then you touched before again on parental leave. And for me, the issue is, look, parental leave's confusing, and the changes that came out in whatever it was, 22, 23, whatever, continues to blow the mind of some of my employers, particularly those who, and again, it's very common in small to medium businesses for families to be employed and couples to be employed. So, you know, when 2 of their key personnel are going to be off on parental leave for God only knows how long at the same time, and they can't say no, that can create a challenge. But it's in the Act now, so what do we do, kind of thing. But for me, where I've seen the biggest confusion is the conflict or the friction between returning to work after a period of parental leave to the role that you held before the leave, mixed in with flexible work arrangements and the right to those because you're a parent. So, and I included in the submission an example of a CEO in a small organisation who came back and wanted to work part-time, and fortunately we were able to negotiate our way through that. But that CEO role wasn't a part-time role, and for her to expect to be able to come back to a CEO role that she could work 3 days a week and be paid at a CEO level from a not-for-profit organisation was ludicrous, you know, but based on the Act, it's viable. It's you know, she has a right. So, yeah, so there for me, there's some of the things that need addressing as the priorities for small to medium businesses.
Thank you. And just to go back to the question around evidence and sick leave and or personal leave, what happens in your experience when there are employees with perhaps chronic illnesses, and how they are able to access leave without necessarily having to get a certificate every time? What kinds of arrangements exist?
Yeah. And look, I think as well is, I've been arguing for years as an HR person that 95% of people come to work with the very best intention to do their best, right? And generally speaking, employees aren't out to get employers unless they get their nose out of joint, and then they'll take them to town, right? But and small businesses are the same. They have every intention to look after their people, and often they're doing it in a way that maybe isn't NES compliant, but they're loving their people anyway. And I find that in answer to that question, if someone in a small business came to the owner and said, I've been diagnosed with cancer, then that employer would bend over backwards to try to support them and give them flexibility and work around it and all the rest of it. Don't worry about it. I don't need a certificate. I know you're going and doing chemo. It's fine. And they're not the issue. That's not what I'm experiencing as the issue. It's the issue is the employees who are disinclined to come to work when it suits them, and how difficult that is for a small business to manage. So, so in answer to your question, open communication is what I normally recommend between the employer and the employee, and let's try to figure this out so that you don't have to. And it's the same. I've got a pod of clients in Gladstone in Queensland, and they struggle to get access to a medical centre because they don't readily have access. So we've had to be sensible and flexible about what evidence we get from employees who are in Gladstone or they live 10 k's out of town or whatever. We're not going to create some arduous thing just for the sake of it. So I think, you know, being open and communicative with the team alleviates a lot of those issues.
Great, thank you. We've probably got time for one more question in here.
Okay.
I'll be quick. And maybe you get both of them
Going
in.
back to the question of parental leave, I mean, becoming a parent is a really pivotal time in someone's life, and it does often result in the parent wanting greater flexibility. But you're saying in your comments that it is often can be problematic and confusing. I'm interested to understand the changes you think that would help to clarify employers' obligations and still protect the employees' rights.
I think, again, it might sound very cliched, but for me it's about communication and preferably before the person takes the leave. Because if before, and assuming that you're birthing a child, before you have your child, particularly if it's your first, you actually probably have no idea whether you're going to come back or not. You might feel that you can't afford to or whatever, but I've also seen plenty of examples where they make it work because the couple really wants for mum or dad to stay at home. So I think communicating beforehand about the role that you're in. Okay, so fantastic, congratulations that you're pregnant and you're planning to take some parental leave, but let's have a conversation about what it might look like when you come back. So at the moment you're planning to take 12 months, that's great. When you return, you may decide that you want some flexibility and you may want to work part-time. Let's have a conversation about what that looks like in the context of the role that you currently sit in and manage those expectations before the person even takes the leave and reach an agreement as to what is reasonable. In some cases, job sharing is a completely viable option. But, you know, using my CEO example, that wasn't ever going to be a viable option, was to have a two part-time people filling a full-time role for them. So, you know, if we can address those things before the parental leave period's taken, I think that would be helpful.
Thank you.
My question, you've raised concerns that increasing NES entitlements can add real cost pressures for small businesses.
Yep.
In your experience, does that start to affect hiring decisions? And if so, how should we balance that against maintaining stronger minimum protection for workers?
So I would say that it's probably not just that in isolation that determines employment decisions, but it certainly contributes to it. So it also contributes to a fear of fixed cost. So I know that the casualisation of the workforce has been an ongoing topic in Australia for a long time, and one the union is generally against the casualisation. But the cause of that is the fixed costs that come with permanent employment. For a small business, it's easier for them to employ a casual and pay a 25% loading that impacts that week's turnover / pay fortnight than to manage the accruals that come with leave and absenteeism and that sort of stuff. So by increasing the number of leave entitlements available to permanent employees and increasing, you know, the number of and minimising the number of hours that someone can work, so a maximum of 35 I think was what's been tossed around, you know, that will impact the decision to employ permanent employees. That will absolutely have an impact because of the fixed cost fees. I guess one of the things that I certainly didn't really think about when I worked in corporate and have had to think about now that I do what I do is the fluctuations that small to medium businesses face in regard to cash flow and revenue that larger organisations just don't face. And flexibility is not something that's really available under awards and the Fair Work Act. So there's been a lot of push from the union over many decades to try and provide some clarity for employees, which I understand and encourage my clients to do, because it leads to two ways of loyalty. You know, if you commit to your employees, you're more likely to get a commitment from them. You know, someone in a full-time job is not likely to leave a full-time job to come and work for you as a casual. So that limits the talent that you can access, and all the rest of it. We have those conversations, but they're fearful of fixing costs, because they've got work this week and they've got work next week and they've got work next month, but they're not sure about the month after whether they're going to have that revenue to be able, or they're going to have the cash flow to be able to pay these people. And so casuals are easy because they can switch them on and off. If you don't have work, you don't call them in. It's simple, you know. So I guess, you know, for me, I mean, it's a big topic, not really something that can be addressed by this committee, but I think it's something that we need to take into consideration when we're looking at the structure of wording around the NES and what we're asking small to medium businesses to do.
Thank you.
Thank you very much. Thank you very much for your attendance here today and for your submission. You'll be sent a copy of the transcript to request any required corrections, and I advise that the committee will now take a break and the hearing will resume at 10:45 a.m. A witness from the Business Council for Sustainable Development Australia to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
Full name? You asked for it. Andrew Ian Robert Peterson, and I'm the CEO of the Business Council for Sustainable Development Australia.
Thank you very much. And although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. And I now invite you to make a brief opening statement before we proceed to discussion.
Thank you so much. So, Chair, Deputy Chair and members of the committee, thank you very much for the opportunity for allowing BCSDA, which is the way we say it really quickly, to appear today. The Business Council is the Australian network partner of the World Business Council for Sustainable Development, which is a CEO-led organisation of over 5,000 companies worldwide and 60 national networks, including ourselves. In Australia, we have 75 institutional members, so not large, but we do have 715 individual subscribers, which includes members and non-members, to our weekly business intelligence service called ESG Snapshot. You may be asking the question, which is a relevant one for us as well, why is BCSDA interested in the national employment standards? BCSDA approaches this through the lens of responsible business conduct and sustainable development. Minimum employment standards are the very part or the very heart of social foundation of a productive economy. For business, the issue is not only legal compliance, although that is relevant, it is workforce trust, fair treatment, consistent systems and ultimately effective governance. Our members' interests in this inquiry and your recommendations include a safety net that supports fair and inclusive work, clear standards that can be implemented consistently, strong compliance incentives and practical guidance, and policy settings that can be evaluated using robust data. That's why our submission focuses less on detailed legal drafting and more on practical improvements to clarity, implementation and measurement. So our interest in this inquiry and your recommendations is not ideological. It's actually quite practical. Can workers and employers actually understand and apply the system? So in our submission, we're not asking the committee to substantially expand or even roll back the national employment standards. Rather, our point is more practical. The NES should be clear enough for workers to understand, administratable enough for employers to implement consistently, and measurable enough for you as policymakers to know whether it's working. Which is why we made 5 practical suggestions. The first, to improve guidance on reasonable additional hours. Second, to publish an NES interactions map so that common scenarios involving hours, leave, public holidays and termination are easy to navigate and easier to navigate. Third, establish a minimum viable indicator set to track how the NES performs over time. Fourth, to develop a legal to data transition guide so evidence can actually be interpreted consistently. And finally, to support small business and supply chain implementation with plain language templates and worked examples. Our view is that these improvements could and should and would strengthen worker protection and, as importantly, reduce avoidable compliance cost and risk for employers. Thank you.
Thank you very much, and thank you for your submission as well. There's lots I think I'd like to ask, but I'm sure our committee members also have some questions. I might just start. The interactions map is a really interesting idea. I wonder if you could describe in some detail what you envisage this map would look like and what kinds of information it would contain, and also I guess within that and thinking about the practical application of this, how would an employer and an employee engage with that material?
Thank you for that. I think the map, or the proposal of the map, is essentially a practical navigation tool. Whilst the law in this area is complex, no, let's call it what it is, very complex, the user experience does not have to be. So many compliance issues arise not because people reject the NES, in our view, but because they struggle to understand how the NES interacts with awards, with agreements, rostering arrangements and ordinary workplace scenarios. So the interactions map that we've proposed would be a plain language, publicly accessible tool that walks through common scenarios such as onboarding and classification, rostering and hours, leave accrual and taking leave, public holidays, termination and also final pay. And it should show where an award or an agreement affects the calculation or process without suggesting that those instruments actually undercut the NES. We hope that this would help workers understand their entitlements, but as importantly, help employers reduce underpayments or errors that are actually caused by the complexity. Our submission also suggests that using the map to identify recurring hotspots for simplification, such as hours averaging, leave cashing out processes, and public holiday edge cases. Hope that helps.
Yeah, no, thank you very much for that. I think we've heard from a number of witnesses and have read in a number of submissions the need to ensure that people get the information in a more simplified fashion to avoid non-compliance and to help people with their understanding of their rights. Do you have any thoughts on how the Fair Work Information Statement sits within the NES and, you know, given the recommendations that you've made around the interactions map, for instance, and other areas, what doesn't it contain that it perhaps could?
Well, I think if we look at what we suggested around the minimum viable indicator set, for example, again, it's important to understand that the NES shouldn't be just legally sound. It should be able to tell whether it's actually working in practice. So our observation around what a minimum viable indicator set would look like is it's a very small dashboard of practical measures that tells us whether the NES is actually working in real workplaces. To be clear, we think it should start modestly, so hours, additional hours, leave usage, unpaid overtime or time off in lieu, where that's measurable, and over time job stability, and then be disaggregated where possible for key worker cohorts. It's quite interesting, even as a very small business organisation, not-for-profit like ours, using Xero is able to drill down fairly quickly into just hours used and unused, and has a measurable impact in understanding as a small business what's the ongoing liabilities, for example. And that's particularly true with payday super coming forward come the 1st of July. The point we think is to move from anecdote to evidence without creating a large reporting burden. Just to go, I think, to one aspect of that, we think that the reason it matters is that the reform debates whether can otherwise become anecdotal. In other words, the better indicators would help policymakers such as yourself see whether the NES is delivering fair outcomes, because that's one of its fundamental criteria, and whether compliance problems are actually recurring. That's another point to it. And whether some cohorts, whether they're women, young workers, older workers, First Nations workers or workers with disability, are actually experiencing the system differently. So the improvement is not, to be clear, more accuracy for its own sake, but whether it's a better feedback loop. In other words, set the standard, support the implementation, measure whether it's working, and then adjust where evidence shows that there is a problem.
And in terms of that adjustment, there's, I think, been a couple of different proposals come from various places around what an ongoing assessment and review of the NES might look like, including the Fair Work Commission using their powers to make change. There's also been proposals around, periodic reviews, statutory reviews, taking into consideration that data that you've described and evaluation. Where do you think an evaluation would best be placed of the NES?
I think, again, to reiterate, the main point for us is that the NES should be easier to apply in the real world. we are not proposing in our submission wholesale redesign. We are proposing some, we think, fairly minimal practical improvements to make existing obligations clearer. As importantly, reduce recurring compliance problems and allow the system to actually be evaluated more transparently over time. As to those particular elements you've highlighted, Chair, I don't think I certainly haven't canvassed key members of our organisation, and therefore I couldn't opine on those points.
Great. Well, thank you very much. I'll just see if any of my colleagues have questions. No? Over here? I think Ms. Baker.
Thanks for being with us today. I just wanted to ask you about templates and the ability to assist employers with the use of templates to improve compliance in small business. I mean, you talk about the NES interactions map,
yep,
which is like an interesting concept. So do you think that there's evidence that such templates are effective? Would they be useful? And why?
Two parts to your question. Can they be effective? I think the answer is where well drafted and the stakeholder who is going to ultimately use it is actually involved in its preparation, very much so. And the proof point there is a number of tools that have been developed, particularly for small business over the last few years at an international level on decarbonisation. So what are the practical steps that can be taken? And there's a very well-known organisation called the Women Business Coalition, of which we are the focal point in Australia, that has what's called the SME climate tool. And it strips away a lot of the rhetoric and the paraphernalia around why you decarbonise. It just says, here are the invoices, this is where you find what your energy is, and this is how you might think about, in 5 steps, undertaking some forms of effective reduction in the cost of your energy use. So it doesn't labour the point in relation to decarbonisation. And then it goes on to, and these are the ways in which you can have checklists that are given to your team to look at this periodically. And so it does it on a quarterly basis, and then it does it on a yearly and then a 3-yearly basis.
So what do you think would be the key templates that could be useful for small business?
Well, I think we have outlined 2 in the appendices, just at a very high level. And I'd leave it at that. I would not burden business, particularly small business, any higher than that. The small business implementation template will, I think, help operation without immediately redesigning things like the safety net. It's just there to help the businesses themselves have an internal checklist so that they are not in breach of the law, but also are thinking about actions that particularly from a small business perspective. I do remember a very famous survey done in 2009 by the then head of the Business Council of Australia, Jennifer Westacott, with the Queensland government. And that asked a very valid question. What does small business actually have to do to reduce its emissions? And to me, that tool is one I still use, because it is so pragmatic and so practical about how you engage your employees at the very beginning, and it's the employees then take it on, rather than necessarily small business. So it's not really an answer to your question per se, but to me, small business loves a simple checklist, but it also loves a checklist where the employees know what their role specifically is as well, and that is part of their overall performance taken into account as well.
Thank you.
All right, well, I will ask questions to you. In terms of the way that the data collection would work, and understanding as well, the need not to put too many burdens on small businesses to do all of the work. What role can they play in contributing that data to that performance framework? Like, what would that look like practically for a small business?
That's a really interesting question, because that question's being asked in New South Wales about how to apply or how to help small business begin climate adaptation. And the recommendation we made is talk to the accountants. And the reason for that is that of all of the government programs that I have witnessed over the years, particularly state-based service programs, they tend to forget that, particularly in rural and regional Australia, a small business, particularly a farmer, will go first to their wife and second to their accountant. And so if you go to the accountants through the CPA or through the CANZ and say, here are some practical tools we would like you to help roll out when you are next talking to your clients, it will help them understand business process, it will help you understand how to help them reduce cost and compliance, rather than having some, dare I say it, top-down approach to implementation. And that's being actively looked at in New South Wales as a pathway for helping farmers particularly learn how the policy of climate adaptation in New South Wales is going to be applied through that particular mechanism. It also is relevant in that case, to be honest, because there are also grants being given to undertake forms of decarbonisation on farm. So it's logical that you go and talk to your accountant about how that's going to be used and applied.
Great. Well, thank you very much for that, and we'll make a note that we should have a look at that New South Wales process that's underway at the moment to better understand that. And would you envisage that that's really done with the support of the Fair Work Ombudsman? A lot of that assessment and data work. Yeah. Probably the appropriate.
Interesting.
Agency.
Yes.
Yeah. Yes. Any further questions from colleagues over here online? Well, thank you very much for your attendance here today. You'll be sent a copy of the transcript to request any required corrections, and enjoy the rest of your Tuesday. Really appreciate your time and your submission. Thank you.
Thank you again.
Oh no, you don't have to do it.
Thank you.
Thank you very much.
I like the idea of some templates. I think
some good things to think about.
female team.
That's absolutely for now. That is fair enough. I'm very sad.
So did you stay here last week? Oh, no,
got it all. I advise that the committee will now take a break and the hearing will resume at 11:15. welcome witnesses for the small and medium business panel to give evidence. And I believe we have a representative of Blue Haven Pools joining us on the line. For the Hansard record, would you please state your full name and the capacity in which you appear?
Ramonda Rose Awadallah, Managing Director of Blue Haven Pools.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. Now, thank you very much for joining us today, and I invite you to make a brief opening statement before we proceed to discussion.
We've been operating in Australia for over 50 years. We deliver residential construction projects and employ a wide network of trades across New South Wales. In construction, we're working in an environment that is unpredictable by nature. With the current framework, including all the national employment standards, it's often assuming a level of control and predictability that our industry doesn't have: weather, site conditions, access, and multiple trades. If I could highlight one priority, would be that I think we need to invest in some faster, more practical training pathways that would be supported by government, because without some skilled people, it's going to be difficult to do the work. But small businesses, we want to do the right thing. We want to employ people, train them, provide stable work, and looking for a system that supports us with some flexibility and recognises realities of an industry like construction. Thank you.
Thank you. Now, we've got a number of committee members here. I'll start with the questions and then I'll see if my colleagues have anything they'd like to add. From your perspective, and appreciating your opening statement there in relation to your description of the construction industry, what do you think the strengths and weaknesses of the current national employment standards are?
Well, they've got a good, solid foundation, but not really reflecting the operational reality of industries like construction. There's, what we feel is that there needs to be simpler compliance, more flexibility in working arrangements, and faster industry-led pathways.
And in terms of the simpler compliance aspect, what are the areas that you think that there is more complexity in that you, and what I guess ideas do you have around how it could be simplified for you?
Well, it is paperwork. A lot of we're regularly. Our main thing for construction is training from scratch. So we're bringing people into an industry with little or no experiences, and there seems to be a problem in formal training pathways that are slow, not aligned with work on site, and small business is absorbing some cost and risk. With employment, these pathways on training, specifically for our pool industry, they don't align, and we're not able to broaden or bring in more employees under this scheme because there are no training pathways for pool builds.
So in terms of the employment standards themselves, though, is it, what in terms of that is the barrier for, bringing people in separate to the training regime? Because I think and how do you think they don't interact or should interact? Are we talking about apprentices here? If you could clarify, that would be very helpful.
Yes, apprentices is a very large component of our construction industry and small business, apprentices and traineeships. The alignment, okay, so I know that we are very focused on the training because we do a lot of work with that. And then there is not so much flexibility in construction too, with weather constraints, with the way that business is run when it comes to employment and weather and trades and availability to materials.
Okay, so I guess it's we're talking about a more kind of casual workforce in terms of that flexibility rather than full and part-time employees?
Full-time. Construction, you need full-time. If we don't have casual and part-time employment is not going to be able to get the skill that's required in construction. All the workforce that we have is full-time, and that can be quite tricky when you're dealing with weather and external forces.
Something we've heard from a number of witnesses and seen in some submissions to this inquiry so far is that sometimes it's difficult for businesses, particularly small and medium businesses, to find out about updates to the national employment standards. What's your experience been of being engaged in getting information from the relevant authorities around the national employment standards? And
that's actually a really great, it's a great question, because there is no actual informing to us directly of those standards. Wouldn't even know really where to start to know of what those updates are unless you're actively seeking them. There's no general advice to us or direct, email or even local business support that really discusses what is available and what the standards are. That needs to be sought out to actively look at it, absorb it, and understand it. There is no one connecting with us as a business to say this is what has updated or this is what's new.
Well, thank you very much for that. And I'll just see if my colleagues have some questions they might like to ask. Ms. Lee?
Thank you. Hi, Ramona. Thank you so much for making a time to appear in today's inquiry. How do you think, you just mentioned there that the National Employment Standards is not readily available and readily accessible. How do you suggest, I think we've heard from one witness this morning talking about that sometimes small business go through through their accountants, or in the rural area go through their wives and then the accountant to then do a lot of the compliance and the paperwork. How do you think business can get access, or what should be done to have it more accessible? And how do you think your business go about implementing the national employment standards?
It is a very, I guess, an area that unless we are actively seeking something or want to make an inquiry about it through an accountant or a paid service, there is very limited, tailored information to come to us as a small business owner. We would need to actively seek it out or pay for it. How could that change? So I guess each industry is a little bit different. Employment is one component, but how does the employment affect each industry, and what are the complexities with employment and in each industry? That is, there could be some more forums or some direct industry training or education rather for individual businesses that could be directly to them, offering maybe some local community discussions or having some webinars or something that could be a little bit more informative, short and sharp when we need to receive this information, especially for updates and changes.
Thank you very much. I'll just see if we've got some questions for this witness, but I'll just for the Hansard as well. We've just had another witness join us who we will speak to in just a moment.
Thank you, Chair. We've heard in this inquiry that some industries there's a growing shift towards more casualisation and flexible forms of work. In your business, have you felt any pressures to move in that direction, and what's driving it?
Downturn of work is driving that. So there is a lot less work. Employment is becoming very difficult to hold on to with not as many contracts to fulfill. So the shift to flexibility in reducing the amount of work and so forth for people has become apparent and very important for the sustainability of us financially. Finding things to do on site is a little bit more difficult because we lose trades, but in an office scenario, it's definitely a shift that we've seen coming over the last 12 to 18 months, where we've had to move people into casual or part-time.
Thank you. And we may have some further questions in a moment, but I would like to welcome our witness on this panel, Mr. Sengley, who's joining us. For the Hansard record, would you please state your full name and the capacity in which you appear?
My name is Sang Lee, and I'm the Managing Director of VIP Karaoke.
Great, and just go through some technical notes now for you. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. Thank you for joining us, and I now invite you to make a brief opening statement before we proceed to discussion.
Look, I didn't prepare an opening statement, I'm sorry.
That's okay, we can get straight down to it if you like.
Yeah, we'll get straight down to it because, yeah.
All right, did any colleagues have a question they'd like to start with?
Yes,
Ms.
hi.
Lee?
Saying thank you so much for making yourself available for this morning. And obviously, I've been talking about, we've been discussing the national employment standards. And I know that a lot of the businesses around the Fowler electorate, some of them have not heard of the national employment standards. But in your work, you've got the karaoke bar as a business, but I know that you've run other businesses before. What are some of the, what do you think are the strengths and weaknesses of the current national employment standards? I mean, a lot of the times people talk about awards and leave and all that stuff, but that is kind of falls under the national employment standards. So what do you think are some of the strengths and weaknesses of the current system?
Okay, so in relation to the strengths, look, it does give structure, so it allows me to know what I'm paying, and I guess it allows me to know what competitors are paying, so that when I do have candidates come look for work, I know roughly what we're competing with, so to get the staff. I guess the weakness is it is rising quite high for hospitality. Hospitality is having a difficult time at the moment, especially now since after COVID and after the war, and there's been a change in trend. So as the rates keep increasing, I think pre-COVID it's increased probably about, in my industry, roughly about $6 an hour per person. So when you talk about $6 per person per hour times that by 10 employees, that's $600 a night potentially. You know what I mean? Extra. So it's starting to wear on the businesses as the rate keeps increasing, and with patronage and trends slowing down. So yeah.
And I think something that has come up quite a bit today, and in also some of the submissions, has been around how information is provided both to employees and employers. So how have you experienced being informed around the national employment standards, and when there are legislative changes, how do you find out about those?
Well, a lot of times when people come in, and especially in this community, a lot of bartenders, in my experience, come from RSLs or places that have pokies. So they actually already tell me exactly how much they get paid at other places. So that kind of, I know that they're going to be correct. But also, I've been using a lot of AI lately. So AI has been very, very informative. It cuts through a lot. So just put in the prompts, ask the award wages, and it really gets down to the nitty-gritty.
Beyond the award wages, I mean, there are obviously obligations on employers from the legislation in Australia in relation to leave provisions, etc. So how have you been informed around those? And, like there have been some updates recently to some of those obligations and entitlements. How would you understand those when they come into effect?
Usually through my accountant. They'll just send me
The council, the council.
Accountants.
Accountants. Yep.
Yeah, accountants thing. And Xero, the software payment program, I use that to give me a guide of how to run through things.
Great. Thank you very much. Colleagues, you've got questions?
You go first.
Well, I'll just, yeah.
I have two questions, and thank you so much for being with us today. So the first one is, what are the biggest employment challenges for employers in your sector? And the other question relates to a previous witness has suggested that the potential benefit of using templates and checklists to help small businesses to comply with the NES standards, but also to meet your obligations. So just checklists that are very simple, particularly for small businesses that are starting out.
So the first question was, what's the challenges? Is that correct?
Yes.
Yeah, it's just and the challenges of finding staff. Is that correct?
Well, really the biggest employment challenges facing you in relation to compliance to the national employment standards.
Okay. Sorry,
That's okay.
Take your time.
I'm finding it very difficult to finding staff at the moment overall in general. To be honest, people aren't looking to work in the hospitality industries as they once were. So that's been a challenge, especially, like I said, competing with like RSLs or whatnots, which is a bigger establishment. So small establishments are finding it quite difficult. And in relation to a checklist, yeah, a checklist would be great. You know, we'd really love checklists. It makes things much more simple, and we don't have to go through a lot of onerous documentation, which can be overwhelming.
Yeah. Okay. I mean, I think it from my perspective, I think it could be very useful if it's just about the minimum basic compliance standards that small business need to undertake when you employ someone initially, and yeah, I think it could be worthwhile. So it's very good to hear that from you, and good luck getting staff. I can imagine it's tough.
It's tough when there's a lot of events, and like Mother's Day this weekend, no one wants to work. Everyone wants to take their mothers out. So we end up having to just try to figure out what we're going to do. But yeah, the checklist would be great. It would make things much more simple.
Yeah. Thank you.
I know you mentioned it's difficult. Oh, sorry, Chair. I know you've just mentioned it's hard to find staff, but do you hire many international students to work in your venues? And if you do, how do you update them about or tell them about their working rights in hospitality, especially in the award for hospitality changes constantly?
Yes, so I had 2 international students that were working for me, and they were actually very aware of their what they need, because they run through the program, and they actually inform me, and then I go to my accountant and we talk about it. I did try to sponsor 2 to come in because of the lack of staff, the applicants. Sponsoring 2 is quite a long process. Getting sponsorship, so getting accredited, takes about 9 months, and you have to jump through quite a few hurdles, which I do understand. They couldn't wait that long, so they end up getting an offer from Maryvale, and they left within 2 weeks of that offer. One within 1 week, because they needed them to work straight away. So retaining staff and finding good staff is quite difficult. So, but yes, international students I've had 2, but they told me everything because they were going through the classes and saying we have this and whatnot. And then before I hired them, I talked to my accountant about what my obligations were.
Yeah.
Thank you. And so we've got obviously both of our panellists with us. I'll just ask, a question for both of you. We might start with Mr. Lee to respond. What one change to the national employment standards or would help you in your business?
I think the checklist is great. I think
Yep.
would be great. That's something that I'm not as aware of all the obligations. It's when things get told to me. So the checklist would be great.
Excellent. Thank you very much for that response. And Ramonda Awadala?
I would love you to ask the question again.
Sorry. Okay. I was just asking, what would one change to the NES be that you think would improve things for you and your business?
I also do agree that the checklist is a great idea. However, I think that the main problem that we're having in New South Wales at the moment, Australia-wide, is actual employees, people who want to work and being able to retain them. I feel like the national standards are almost rewarding people to not work or to have lots of flexibilities. Just hearing the story beforehand that everybody in hospitality wants to take that time to be off on Mother's Day and within their rights for, time off. It's very difficult to get a flow on in business when there are so many days off, paid family leave, all of these things in the national standards. Very difficult for small business to get a shake on and do what we need to do, construction and hospitality and many other industries. We too also look overseas for employment, for general admin things, because it is a much cheaper and a much more reliable system.
Thank you. And I'll just see if there are any final questions from your colleagues. Great. Well, thank you very much, both of you, for appearing today and answering our questions. You'll be sent a copy of the transcript to request any required corrections. It's a beautiful day, so our witnesses can now enjoy that. And I declare this public hearing closed. Thank you so much.